Please be seated.
Good morning.
Good morning. And this is the matter of State of Washington versus Edward C. Troyer Jr., Pierce County District Court, case number 1AC 002225. My name is Jeffrey Jans. I'm a Kitsap County District Court judge who has been appointed visiting judge to preside over this case. These proceedings are being live streamed through the Pierce County District Court website. Viewers are reminded, however, that they are prohibited from photographing or audio or video recording these proceedings without the prior permission of the court. This prohibition also applies to observers in the courtroom. The live stream feed is being shown in the courtroom on a large monitor to the observer's right. Only credentialed media, which have been granted permission from the court in advance, are permitted to photograph, audio, and or video record these proceedings as outlined in the court's November 4, 2022 media coverage order. To courtroom observers, jurors have a duty to decide this case based upon the evidence presented. To ensure that both parties receive a fair trial, it is my duty to minimize the risk that jurors are influenced by external factors. For that reason, courtroom observers are prohibited from wearing clothing or accessories with political or social justice messaging. If you are currently wearing or displaying anything that meets that description, please cover it up and put it away. And thank you for your cooperation on that. And good morning to the parties. When we left yesterday, there was a issue concerning cross-examination, and I did receive a brief from the state in response to that, so thank you for preparing that. That was helpful to have that. And I assume the defense got a copy as well?
Yes, sir.
All right. Is there anything else we need to discuss other than this particular topic? Because I thought I'd take care of that administrative issues first, if there
Yes,
are.
I think I forgot to bring up yesterday, the court had wanted, when we played the enhanced body camera of Officer Hobbs, right? The court doesn't want that to go on forever. So we've marked State's Exhibit 12, which is simply the part that was played in court. So it's actually their enhanced body camera video. So we'd ask that this be admitted, but I want to know how we should handle the fact that the entire thing was admitted previously and isn't going to go back to the jury. I don't know if we need to swap them out somehow. Do you see what I'm saying?
I do, and what the staff talked to me about that too. And so 12 was admitted as the whole video that wasn't shown. What we're going to do is switch, and now 12 that is admitted is what you presented, which is the one that was shown, and so we'll call 12A the full unredacted version. So 12 is admitted and is redacted, 12A is, so.
It's just backwards, the redacted.
We change it, right. And in that way, my experience is that if we do a 12A and send that back to the jury may speculate, well, where's 12? And why are there no other A's for other ones? So I just decided to switch. And so 12 is the one that was shown, 12 is the one that was admitted, 12A was not shown, and 12A hasn't been offered. But it's the full unredacted version. So I knew that was a little confusing, but the staff and I talked about it, and that seemed like the best way to go. And thank you for providing the unredacted one. We haven't, and we will get to that eventually. We haven't got into whether their playback machine should be allowed in the back, but that would, it's going to matter either way with respect to what we send to the jury, that they only have what's been admitted and shown to them in court. So thank you for bringing that up. So, and thank you for providing that copy too.
And thank you to court staff for sorting that out.
Anything else from the state other than the motion?
No, Your Honor.
And defense?
Nothing right now, Your Honor.
All right, thank you. And I didn't verify this. All the jurors here?
Yes, Your
All
Honor.
right, good. All right. So as we had some discussion yesterday. The court ruled preliminarily. The state wanted more time, and then there was also a power issue the state had from the day before, which, you know, that kind of limited what they could research, and so I gave some more time for that, and they presented a brief, but I want to have a chance to have you all have additional argument if you want to present it, because I want to make sure everyone has a chance to present to me what they want the court to consider in this. So I'm going to go ahead and start with the state, because you provided the new information, and I want the defense to be able to hear that as well, unless you...
Before we get started, I actually had a delay getting here today, showed up sort of right at 7:45, and I'm reading the state's brief. Luckily, they haven't cited any case law, but I haven't got through it yet.
8:45.
8:45.
Yeah.
Got here at 8:45.
You want like 10 minutes or something with that?
That would be great.
Oh, yeah, yes, I want you to be able to read it too.
Okay.
Yes,
All
absolutely.
right, so if the parties would let the staff, I'll take a recess. If the parties let the staff know when they're ready to go, then I'll just come back on the bench. So court's at recess.
Thank you.
All rise.
Thank you. Please be seated. I wanted to let council know, and you probably saw this too, I found a state Supreme Court case, State versus Rivers, this morning in my research, 129 Washington 2nd, 697. It's a 1996 case, and it's concerning Head Note 7. It was the only case law I could find concerning cross-examining a witness about a statement their lawyer made in court or in front of a judge. And so that it's just Head Note 7 is the reason why I presented it, and it's not exactly on point with what's being discussed here today, but it was just the only case I could find, and I wanted to have counsel get a chance to look at it, and maybe that affects your argument, maybe not, but
Your Honor, thank you for that, and I did have another site that I'm looking at now, which is Vashon Island School District at 87 Washington 2nd, 958, and I'll take a look at that. And then, of course, 801 D2, C and D. Thank you. And the Teglin annotations.
Mr. Gross, have you had enough time?
Yes, thank you.
Is the state ready to proceed with argument?
Yes, Your Honor, thank you.
Please, thank you.
First of all, thank you so much for the time to respond. The situation here was as follows. The defense sent the brief the prior night. I did not see it till the next day, and I had a civilian witness, so I had my hands full, and I read quickly the brief over lunch, but at the time I addressed the court, I had not even read the Ruiz case. So thank you for the opportunity to let me read that case. My argument yesterday was based solely on what I was quickly able to figure out from their brief as to what Ruiz said. In reading that yesterday, I did not feel that Ruiz was in any way on point or helpful to this case, and I did not take the time to read Ruiz, and that is my fault. So I appreciate that I was able to do that and now file the state's response. Now, having since read Ruiz, that simply affirms the state's position that that case is not applicable to this situation, nor is it even persuasive in terms of what occurred here, which is completely different. So in State v. Ruiz, the Court of Appeals confronted the issue of a prosecutor calling a witness to testify at trial in front of the jury solely for the purpose of having that witness repeatedly invoke his Fifth Amendment right not to testify after the court had already found and obviously advised that witness that that privilege did not apply. The trial court had already determined that he didn't have a privilege, but he continued to evoke repeatedly and refused to abide by the court's order and answer any questions at trial. And the court in that case reasoned that the questioning party, quote, is not attempting to exploit a privilege, but rather is attempting to gain evidence from a witness who had no legal base, who has not had, no legal basis to decline to provide information. And Your Honor, that's not at all what happened here. What happened here is that multiple witnesses invoked their right to remain silent. The court then ruled that those invocations were not valid. Afterwards, every witness, including Officer Lawless, then answered every question. That is entirely different from the situation in Ruiz, where after the court found there was no privilege, the witness continued to refuse to answer any questions, which is why the Court of Appeal talks about that being used as an attempt after the privilege was found to be invalid to gain evidence from that witness. And that's not what happened here. The defense hasn't been deprived of anything. Officer Lawless and every other witness answered every question and followed the court's order when they were advised that it was not a valid invocation. And that difference here is the defining and relevant distinction between what's going on here and Ruiz. The witness in Ruiz refused to testify after the trial court had already ruled that he didn't have a valid Fifth Amendment claim. Therefore, that witness refused to testify with knowledge that his legal claim was without merit. And the Ruiz court compared this situation to a witness who, quote, simply declined to answer a question or a series of questions without any basis, because at that point the Fifth Amendment claim had been denied, permitting an inference that the witness was protecting someone else. But here, Officer Lawless complied with the court's order ever since his good faith invocation, and his conduct bears no similarity to what happened in Ruiz, which was a defiant, unlawful, and invalid invocation. Now, the defense keeps referring to these invocations as his bogus invocation, and I disagree with that. Several attorneys in this case, including Officer Lawless's attorney, invoked, and they made a colorable argument that they had the right to invoke. Now, as the court knows, the state disagrees with that. The state argued that the Fifth Amendment, that they did not have a colorable Fifth Amendment right here. But I think it's important to note that multiple attorneys who were representing multiple witnesses made this argument, and it was colorable. And after the court denied it, they all answered their questions, every question. And again, that's completely different in Ruiz, where the argument was rejected, and that person still refused to answer questions. That's simply not what happened here. So that gets us to the State v. Orne case, which then guides the analysis after we have the facts that I've just put forth. And Orne, as you know, is a case that the court provided about the right to cross-examine witnesses. And that case indicates that of course, is not a limitless right. And it says this: consistent with the Constitution, trial courts may, quote, exclude evidence that is repetitive, only marginally relevant, or poses an undue risk of harassment, prejudice, or confusion of the issues. That's at 352 in the Orne case. And it mimics the language of Evidence Rule 403, of course. And then the Orne court goes forth and it gives 3 steps to follow in determining whether evidence should be allowed during cross-examination. First, the appellate court asks whether the excluded evidence was at least minimally relevant. Second, the court asks whether the evidence was so prejudicial as to disrupt the fairness to the fact-finding process. And third, the court asks, quote, whether the state interest in excluding the prejudicial evidence outweighs the defendant's need to present it. And we submitted in our brief that using those factors, this weighs in favor of denying the defendant's motion. First step, the evidence the defendant seeks to admit on cross-examination is not even minimally relevant. They have not articulated any reason why Officer Lawless's prior pre-trial invocation tends to besmirch his credibility or demonstrate a bias when he was simply following the advice of counsel and subsequently followed the court's order to answer every single question. And as explained in the brief earlier, those circumstances of Officer Lawless's invocation do not support any negative inference regarding his truthfulness or bias. He simply followed the advice of counsel, which I would submit any lay person would do. In fact, if I had an attorney in some kind of case that particularly was not my area of specialty, I would follow the advice of my attorney. Anybody would do that. The second part of the Orne analysis is in the absence of any rational relationship to Officer Lawless's bias or credibility, the evidence simply serves to unfairly cast him as though he has something to hide. It seeks to impugn his character simply for exercising his due process right to have this court determine whether he had a valid Fifth Amendment right in the first place. There was a colorable argument, it was denied, and then he answered all questions. And it is unfairly prejudicial and would disrupt the fact-finding process to bring in all of this stuff. Similarly, the defendant's proposed line of questioning will inevitably lead to extended follow-up from both parties on what is a very collateral issue here, such as the validity of the Fifth Amendment claim, the good faith nature of the invocation, his confidential communications with counsel, which are privileged and therefore I can't get into, and whether he even knew that others invoked here. And that brings me to something not in the brief, which is that this prejudice here is heightened based on the timeline that we have here. As you know, the court asked me to contact the attorneys and find out, well, what's going to happen at trial? Are they going to invoke at trial? And once I had that information, I brought it to the court on Wednesday, November 30th, and at that time the court ruled that the prior invocations would not be the subject of cross-examination. Now, since then, 6 days have passed. Officers Ventura, Barron, and Hobbs have all testified. There was no discussion about them having invoked because the court had granted that motion. So the situation now becomes 6 days later, 6 working days later, the defense files a brief specifically to try to get this information in only for Officer Lawless. And we didn't have the opportunity to show that everybody invoked here. Every TPD line officer who arrived at this scene invoked. So what this looks like to the jury now is that the only person who got an attorney and invoked was Officer Lawless, and that simply heightens the prejudice here. These are collateral and complicated issues that are going to be presented in front of a lay jury, and it brings out all sorts of things that they can't possibly understand, or the witness may be unable to testify to, who's also not a lawyer, such as, for instance, as the court knows, you have to invoke for every question. Why? Because that's the law. But what that ends up looking like when the defense examines the witness is that he invoked 100 times. And they're not going to understand that the law requires that. It just looks like somebody who is invoking over and over and over and over again with this inference that the state's not going to be able to rebut due to the attorney-client privilege, that he just said 100 times, I don't want to answer any questions. That's highly prejudicial. And there's just no way to address it without piercing the privilege. Third and finally, the foregoing considerations demonstrate that the state's interest in excluding this evidence outweighs the defendant's need for it. That's the third Warren factor. Here, the supposed bias evidence, which apparently is following your attorney's advice, in this case is far less compelling than in Warren, where the defendant was prohibited from impeaching the alleged victim and primary witness against him by inquiring into his confidential informant agreement with the police. And even under those circumstances, our Supreme Court observed that, quote, if the single question allowed was not misleading, because remember, it was misleading to the jury, this case would be much more difficult. And even after finding error and talking about the misleading nature that was then presented to the jury in that case, the Supreme Court still concluded that that error was harmless beyond a reasonable doubt. And I'll end with this, Your Honor. The defense here has not been deprived of anything in their right to present a defense. This ruling is literally punishing this witness for doing what anybody else would do. which is following his attorney's advice. And it punishes the state when we were the ones who came to court and got the CRLJ 4.6 motion, which the court granted to make sure that everybody, including the defense, could thoroughly question every witness. They did that. There is not a single question in the record, which the court knows because the court was there, where this witness or any of the other witnesses failed to answer a question. They have not been deprived of anything. And the state would ask the court to exclude this irrelevant or even minimally relevant evidence, which is highly confusing, highly prejudicial, and leads us to this distracting sideshow in front of a jury composed of lay witnesses trying to make sense why a witness would invoke 100 times.
Thank you.
Thank you.
Mr. Gross?
Well, your eyes are not as bad as mine, but there you go.
Should I give you your? There he goes.
Thank you, Your Honor. So the first thing that Ruiz tells us, which the court found yesterday, is that an invalid invocation of a privilege is not a privilege. So we are not talking about privilege case law or privilege analysis, which the state seems to concede in their brief by not addressing that. So we're really dealing with the rules of evidence here. Is it relevant that Officer Lawless invoked when he did, under the circumstances he did, on the occasions that he did? And this is really where Orrin comes into play. A criminal defendant has a Sixth Amendment right to cross-examine witnesses on bias and credibility, and that right is particularly strong if the witness at issue is a material witness. And Officer Lawless is a critical witness in this case. We're not arguing here that the invocation, Officer Lawless's invocation, deprived us of information. I think we've made that pretty clear in our brief. Our argument is that his invocation demonstrates his bias and lack of credibility. And it absolutely does go to his bias and credibility. He had a private meeting with the state days before his deposition where he voluntarily talked with them about this case. He then showed up for a deposition and invoked to almost 400 questions from the defense. Every single time he invoked, the court told him he was wrong, rejected his invocation. Ruiz tells us that an invocation that's invalid is akin to a refusal to answer the question. That's what that is. He's trying to refuse to answer the question, and the court is ordering him to answer the question. The state then questioned him after the defense was done, and he didn't invoke a single time. Now, the state didn't ask him a lot of questions. I think I counted 13. But what matters is that he didn't invoke to any question the state asked. And this is after having a private meeting with the state, where obviously he didn't invoke. And it's also relevant that he invoked on the same topics that the defense was asking him about, that he invoked when the defense asked him about it. It's also relevant that Officer Lawless did not invoke to every defense question, and it appeared he was doing some mental analysis about which questions to invoke to and which not. However, he invoked to certain questions that strike at his credibility, including whether his report was accurate, and questions about whether his conversation with Officer Troy or Sheriff Troyer. The fact that he tried to refuse to answer questions about that, and said that the answer to those questions could subject him to criminal liability, that goes to his credibility. The state disagrees that that evidence goes to his bias, and they're certainly able to argue that. But that goes to weight, not admissibility. The state also argues that that admitting evidence in this, or evidence of his invocation, is going to lead to extended follow-up questioning from them. That's their decision. What we're going to question him about are the circumstances and the fact of his invocation. And if they want to get up and try to get into the uncomfortable topic of why he invoked, what his attorney told him, questions that touch on the attorney-client privilege, that's the state's decision. It's not his fault that his attorney told him to invoke, if that's what happened. And just because a question might lead to further questioning that might touch on a separate privilege is not a basis to deprive a criminal defendant from asking questions about a witness's credibility. The state also posits that asking him about whether he invoked is going to open the door to follow-up questions about whether other officers invoked. And we move now to prevent that line of questioning. Whether other officers invoked is completely irrelevant. As this court found yesterday, Officer Lawless is his own person, and it was his decision to invoke, not his attorney. His attorney did not invoke. His attorney had no right to invoke. He invoked. The state just argued, and maybe I misheard it, that the law required him to invoke to every question. No, it doesn't. Not at all. The fact that he's going to come here today and not invoke underscores that. It's his decision to invoke or not. The state actually disagreed with his decision to invoke in the first place, as it just said. He was not forced to invoke. He made a conscious decision to invoke. The state argues that it's punishing the witness to let us ask questions about his invocation. He's a witness in this case. He's not the defendant. He's not being punished. There's no negative consequence for him. And they argue that the state is going to be punished by us asking questions about this. The state's not on trial here. The state doesn't have the defendant's rights. If the court would like me to address the timing of our briefing, I'm happy to do that, but the court hasn't asked me to do that.
It's up to you.
Wait. You should also put this in for the record from Tegland. 607, and our right to inquire into bias, confrontation clause in this. I can if you want to. Yeah, I just wanted to also add that also under Rule 607, of course, in the annotations in Tegland, in criminal cases, and I'm at 607.3 at page 303, in criminal cases, the right to cross-examine for bias is considered to be an extension of the Sixth Amendment right to confrontation, and I've omitted the citations. And it states parenthetically, defendant's right to confrontation violated when a trial court refused to allow him to show that a prosecution witness had reason to be hostile against him. And later on the page, Tegland states, nevertheless, it's been repeatedly stated that in criminal cases, the defendant should be given wide latitude in cross-examining prosecution witnesses to reveal bias, and I'm omitting the citations. That's all page 303 and the section that I mentioned. Thank you. In the most recent Tegland. Thank you.
I guess I'll address the timing of the briefing because the state, I think, maybe made the implication that it was tactical, the timing of our briefing, because all the other officers have already testified. I'll just say that the state made an oral motion in limine in the middle of this trial to prevent us from questioning witnesses about their invocation. They didn't cite any cases. They certainly didn't cite Ruiz. And we told the court we're going to try to find authority and present it to the court when we can. Obviously, we've been very busy. We asked another attorney at our office to do some research on it. She did and couldn't find anything. We then asked another attorney who found Ruiz after 5 hours of research. It's a hard case to find. And then wrote a brief that day, and we submitted it that night. So it was not tactical at all.
Great.
Thank you, Mr. Gross. Ms.
Can I
Tratnik.
respond briefly? Thank you. Your Honor, the defense asked, is it relevant that he invoked? And that is the whole point. No, it is not relevant that he invoked. All he did was follow the advice of his attorney. And that doesn't go, following the advice of your attorney doesn't go to bias or credibility. They indicated that, and the court was there, which I think is very helpful, that at some times Officer Lawless was sort of going through this mental analysis as to whether or not to invoke. And that's because he's not a lawyer, and that is what the problem is with this whole argument. And it is a requirement of the law that you invoke for every question. That is a legal requirement. In fact, I think the court even brought it up during the depositions.
That you validly invoked the Fifth Amendment to each question.
Yes, and he was making a colorable argument to preserve his right to challenge that if the court were to be incorrect. Now, as you know, the state doesn't think that was a colorable argument. We argued, to Your Honor, that it was not a valid invocation and that you should find so and make him answer questions.
And the court completely agreed with you on your analysis.
Yes, thank you, and I think that we are correct, but in order to preserve their objection on appeal, if they wanted to, they need to invoke to every question. That's the legal analysis, but what the layperson jury is going to find here, this is not about weight versus admissibility. This is about something a lay witness did on the advice of counsel and a layperson jury looking at this. And they're not going to understand all the complicated and legal issues here. What this is going to look like is that a witness improperly, continuously refused to answer questions. That's what it's going to look like. And that is not valid. And that's not what happened here. And I think simply asking for the state to ask the witness, well, after your lawyer was found to be wrong, did you answer the questions? That doesn't solve the problem of things such as invoking 100 times. Also, in terms of the timing of when they raised this, whether it was targeted or not, the result here in waiting 6 days is that Officer Lawless will now look like the only person who invoked 100 times, and it makes him look like he had something to hide. And I think the state cleaning it up by saying, well, did you ultimately answer every question? I just don't think that that solves that problem. I think it's highly prejudicial. I think it is highly confusing. It is a bunch of complicated and collateral legal issues being presented to a layperson jury. And it is not Ruiz where the court found that the fact-finding process was disrupted by a defiant witness who refused to follow the court's order and not answer questions. That is not what happened here, and that's why it's not applicable.
Thank you. Defense, it's your motion. I should give you last word if you want.
Very briefly, the state says it's going to look like he invalidly and improperly and inappropriately invoked, and that is exactly what he did. And we're not arguing that he failed to follow the court's instruction. He did follow the court's instruction. When he ordered to answer the question, he ordered it. But that's not what matters. What matters is what he did before that. And then finally, what the state keeps not addressing is the fact that he treated the defense and prosecution differently, which goes to his bias. He never, as far as we know, asserted the Fifth Amendment in his private meeting with the prosecutor, and then asserted it throughout the defense questioning, and then never asserted it again during the prosecution questioning. The state didn't address that.
And I meant to, can I have like 30 seconds?
Of course.
To remind the court that there was a prior proceeding at the behest of the state where all of the officers, including Officer Lawless, invoked all the time. And what they're looking at here is the end of the transcript, and the court was there about this private meeting, which the defense was trying to make look like some nefarious issue. Ms. Serrano handled that because I had to go make a phone call, and that's on the last page of the brief here. And there were 13 questions by the state, and they were limited to 2 purposes. One, the state asked him to get up, 6 questions to clarify something he had written on the map. Of course, you're not going to invoke to that. And then the second set of questions was about this nefarious private meeting, which the officer explained, and I will represent to the court. They wanted to review their transcript from the prior proceeding. And as the court knows, under a prior court order, the state can't release that. The state can't email it to somebody, they can't mail it to something. So we set up this meeting where him and his attorney drove up, and that's what he testified to in the deposition. We handed them the prior transcript, put them in a separate room, shut the door, and when they were done, they came back and they handed that transcript back to us. That's what those questions were. They weren't anything about the event in question. They were about cleaning up a map, and again, it's on the last page of the deposition that they provided. It was about cleaning up a map and explaining why we met with them, which was limited to handing them a transcript and requiring them to review it where we could make sure it got back to us without getting anywhere else.
Thank you. Mr. Rose?
Your Honor, just because we're talking about the facts, I'm not going to make any more argument. I just want to clarify. This is what Officer Lawless himself said about that meeting. We talked about aspects of the case, but nothing, like I said, nothing new, nothing strategic or anything. It was just, we're having, again, through my lawyer, having a discussion about the case itself.
Thank you. The First Amendment provides for 5 separate rights, and one of the rights is freedom of association. And what this means is that anyone has the right to choose who they want to associate with and who they do not want to associate with. A witness who chooses or indicates that they do not want to be interviewed by either party in a criminal case has a constitutional right to do that. They do not have to agree to an interview. But like most constitutional rights, there are limits to this. And when a material witness refuses to speak with either party in a criminal case, there is a process. And that's what happened here. Officer Lawless refused to be interviewed by the defense counsel and the state, and that was constitutionally protected. So a good example of why there are limits on this would be jury duty. I mean, it's entirely possible people that get summons for jury do not want to associate with the court and be jurors. They have to come anyway, and their First Amendment right in that matter, in that situation, is limited because they have to come to court. So their freedom of association, even though they have a First Amendment right, is limited. CRRLJ 4.6 recognizes this First Amendment limitation so that if a witness in a criminal case refuses to speak with either party, the process is a party can come to court and ask a judge to order that witness to submit to a deposition, which was done here. And so the court here ordered Officer Lawless found he was a material witness and ordered him to appear at a deposition, answer questions under oath, and the reason why is to prevent a failure of justice, which is the phrase that's used in CRRLJ 4.6. There was some discussion yesterday afternoon about whether the defense wanted to argue or would argue that Officer Lawless obstructed the defense investigation, and the court is going to prohibit any cross-examination or argument on that topic. Officer Lawless did not obstruct anybody by exercising his First Amendment right to not be interviewed by either party. He did attend the deposition, and so there was no obstruction, and that would be improper argument or even improper questioning of Officer Lawless, so the defense is prohibited from getting into that topic. The deposition of Officer Lawless was held on October 20, 2022. It was held from 9 in the morning till 4:40 in the afternoon. We did have some breaks. It was a very long deposition. Officer Lawless refused to answer almost every question the defense counsel asked of him during that deposition. The deposition is 303 pages long and has been attached to the defense motion. The first refusal to answer a question by the defense was on page 14 of the deposition. The last refusal was on page 297 of the deposition. So we have over 260 pages of deposition where Officer Lawless refused to answer defense questions. The state did ask some follow-up questions on page 297 to 300 of the deposition. Not one time did Officer Lawless refuse to answer any question posed by the state. And some of those questions involved the incident in this case. During each refusal of Officer Lawless to answer the question, the defense, as the process is required by the Fifth Amendment, was required to ask the court to order him, Officer Lawless, to answer. That was presumably the reason why the parties asked me to be at that deposition, and I did. And every time the state asked the court to order Officer Lawless or the defense asked the court to order Officer Lawless to respond. When he refused to do so, the court did so. Officer Lawless was ordered to answer every time. It is accurate, and the parties have mentioned this, that Officer Lawless's lawyer was there, and there were discussions during several times of the deposition concerning the defense, or concerning Officer Lawless's lawyer's legal analysis why the Fifth Amendment should apply to the questions that were posed by the defense. The court responded at pages 15 to 17, 21, 34, 71, and 72 with respect to those arguments. And obviously, both counsel here were similarly allowed to respond to the invocation of the Fifth Amendment. The defense, not only the state, but the defense made a strong argument to the court that based upon the reasons that were given by the defense attorney, that there was some theoretical or possibility Officer Lawless could be charged with a crime. Both parties argued to the court that it was not a valid assertion of the Fifth Amendment and that the court should order Officer Lawless to testify. Both parties in this case were persuasive to the court. And in fact, on part of the transcript, I went through a pretty lengthy analysis of the Fifth Amendment, citing Washington case law and U.S. Supreme case law about why the reasons given by defense counsel were just simply too subjective, and they weren't realistic with respect to the likelihood that the answer to the question could subject Officer Lawless to criminal liability. And the court was consistent throughout the entire deposition. The court never found the invocation of the Fifth Amendment right asserted by Officer Lawless was valid. And in fact, it found every assertion was invalid. This is despite the court repeatedly, when asked by the defense, after Officer Lawless refused to answer the question, despite the court repeatedly requiring Officer Lawless to answer, he continued to refuse to answer defense questions for over 250 pages of that deposition over the course of probably about 9:30 to 4:30 when his questioning was done by the defense. He refused to answer. The officer knew that the invocation was rejected by the court, not 10 times or 20 or 30 or 50 or 100 or 200, probably around 300 to 400 times the court continued to reject the invocation of the Fifth Amendment. This forced the defense to continue to ask the court to order Officer Lawless to answer, even though he invalidly refused to answer by asserting the Fifth Amendment. As the court notified you when I first became involved in this case, I did write a prosecutor ethics and professionalism manual. The third edition was in 2008. It's called The Quest for Justice. It's still being used today to teach prosecutors, defense lawyers, and is available to the public through the Prosecuting Attorneys Association website. And it's an important document in this particular topic. At page 25 of the manual, the ABA Standards for Criminal Justice, the prosecution function, state that a prosecutor is an administrator of justice. And by that phrase is important because what that means is a paramount duty of a prosecutor is to seek justice, not merely convictions. And that is what I believe the state's attempting to do in this trial. Well, how does one seek justice? Well, it's about trying to determine the truth. Well, in a criminal case, how does one determine the truth? The United States Supreme Court a very long time ago has determined that cross-examination is the greatest device ever invented for determining the truth. And so by that U.S. Supreme Court analysis, the right to cross-examine has been incorporated within the Sixth Amendment rights that every criminal defendant has in this country. That right is also incorporated in ER 607 that was discussed by the defense as well. So this is a significant right to cross-examine by the defense to attempt to learn the truth. And that's what State versus Orne discussed, which I provided the counsel quite a while ago. It's a March 18, 2021 case. At paragraph 18, the Supreme Court states that cross-examination is especially important to reveal potential bias, which is always relevant as determining a witness determine a witness's truth and for the jury to determine the weight of the testimony to be given. So cross-examination to reveal potential bias is always relevant under ER 401 and 402. Paragraph 18, the Supreme Court continues that this is especially true when the witness is a prosecution witness and the defense is seeking to cross-examine about bias. And the Supreme Court said that trial courts, as this one, are to give wide latitude to the defense to ensure that their fundamental right under the Sixth Amendment to cross-examine to determine the truth is effectuated concerning potential motive, bias, or credibility of that witness. The court finds that Officer Lawless is an essential and material witness for the state. Why? At pages 246 and 249 of the deposition, Officer Lawless testified under oath after refusing to do so, improperly invoking the Fifth Amendment and the court ordering for answer. He testified that Mr. Troyer told Officer Lawless that Mr. Altimer did not threaten Mr. Troyer. That's the testimony that Officer Lawless provided during the deposition after being ordered to answer. This is a critical statement in the case, which would logically want to encourage the defense to explore every avenue of potential bias, motive, or credibility issues. So with this background, going to the Ruiz case, and the state is, I completely agree with the state, the fact pattern there is not the fact pattern here, and you all looked for a long time. Clearly, there is no fact pattern you were able to find in any case law that meets what we're talking about here, but there are some things to be gleaned from Ruiz. In that case, the state called a witness. The state knew the witness was going to assert the Fifth Amendment, and the appellate court said that was still proper for the state to call that witness, knowing the witness would assert the Fifth Amendment. The court, in that case, also said the assertion was invalid, and the court had ruled on that, but that did not mean the state could not call the witness and even invoke the Fifth Amendment in front of the jury. The state was allowed to obtain that evidence and let the jury know the Fifth Amendment had been invoked, even improperly. Here, the state is offering and seeks to call Officer Lawless. The state knows that Officer Lawless invoked the Fifth, improperly, invalidly, as they argued, invoked the Fifth Amendment and that deposition hundreds of times. So the question becomes, as presented by the parties, is Officer Lawless's invalid invocation of the Fifth Amendment and refusing to answer defense questions under oath biased toward the defense when, at least in the pages at the end of the transcript, Officer Lawless did not refuse to answer any questions posed by the state, some of which involved this particular case. Court finds that that series of events, invalidly invoking the Fifth Amendment and refusing to answer any questions, but for the court ordering it to be answered hundreds of times when the Fifth Amendment was not invoked validly or invalidly, when the state asked questions also about the incident, potentially reveals bias of this witness toward the defendant. Is there bias? That's for the parties to argue, but does it potentially reveal bias? And the answer, the court finds that that's yes. Rivers, which is not on point, although it does present the idea that it's permissible for counsel to ask a witness about statements made by counsel. And in the deposition, Officer Lawless, counsel was present, and there was lengthy argument with Officer Lawless there by his attorney and by the counsel in this room discussing the Fifth Amendment right. And after that discussion, and I already cited the pages where I ruled, found that there was no valid basis for it, yet the officer continued to invalidly invoke. The state argues, well, sure, he did that because his lawyer gave him that advice. That could be true or not true. Potentially that'll be something we'll resolve. But that goes to the weight as to why he refused to answer questions and why he refused to answer only defense questions but didn't refuse to answer any state's questions. I don't know if that was legal advice or not, but that goes to the weight as to explaining why he refused. It doesn't go to whether or not the jury should hear that he did refuse to answer defense questions and not state questions during the deposition. The fact that the Officer Lawless may have invoked the Fifth Amendment and invalidly invoked the Fifth Amendment based upon the advice of counsel does not sanitize the defense or sanitize the witness from the defense attempting to examine and ask about bias as to why Officer Lawless chose to do what he did, and both the parties have understood and agreed that, you know, it's a witness, it's Officer Lawless who made the decision to invoke the Fifth Amendment. Could have been based on advice, that's logical to me, and I agree with the state on that. But why he did that, it still was his choice to invoke, and his choice apparently was to not invoke when the state asked questions. That shows potential bias. So the court rejects the state's argument that Officer Lawless's invalid assertion of the Fifth Amendment, based presumably on legal advice, should sanitize Officer Lawless from being asked questions about his bias, potential bias from the defense. Again, this goes to the weight, not to the admissibility. As Orn directs, the court is required to give wide latitude to the defense on this topic, given that Officer Lawless is a key witness for the state. And the court's going to follow the state Supreme Court on this. So the defense, if it chooses, may cross-examine Officer Lawless on his refusal to answer defense questions during the deposition. And the breadth of that, you're going to be given wide latitude on that. The state argues correctly that there are limits to the Sixth Amendment, to defendant's Sixth Amendment right to cross-examine, and that's actually been exhibited here. And the court has a couple of times agreed with the state and prohibited the defense from getting into some evidence. For example, the state asked the court to prohibit the defense from eliciting cross-examination or argument concerning Mr. Altimer's driving status, driver's license status, as well as what a warrant that was outstanding for his arrest. The court agreed, and actually, considering Orn and the Sixth Amendment, still prohibited the defense from eliciting that testimony. It found it was improper character testimony.
Sorry.
That testimony was not offered to show bias, or the court did not agree that about driver status and arrest would show bias, and so the court rejected that argument. Evidence of a witness's bias is always relevant under ER 401 and 402. The state raises evidence rule 403, and that's, of course, well known to the parties, and the weighing about whether relevant evidence should be permitted, should be excluded based on other reasons, even though the evidence is relevant. The Tegland makes clear that potential bias evidence of a witness is highly relevant, and when it's a defense attorney who's seeking to cross-examine a key state witness, its relevance is even higher. So it's an extremely high relevance. So balancing that high relevance, can it be said that the probative value of that evidence is substantially outweighed by the danger of unfair prejudice to the state, unfair surprise, etc.? And the answer, and Tegland teaches this, is that no. When evidence is highly probative, it is not proper for a court to exclude that evidence because the probative value would always outweigh contrary concerns. The state does discuss several of its concerns of issues that may arise based upon the court's decision to allow this potential bias evidence to be examined. Concerning the validity of the Fifth Amendment, again, I'm not aware of the prior proceeding where the judge found Officer Lawless's testimony to be the Fifth Amendment to be validly asserted. I never found that it was validly asserted. So the validity of the Fifth Amendment, I'm not sure that's an issue before the jury. It was not a valid assertion. Whether the officer asked in good faith, whether it's going to present other issues, whether it wastes judicial resources, the state presented all of that. If the state's paramount concern is that, it just can choose not to call Officer Lawless. But if it chooses to call Officer Lawless, the remedy should not be of the state's concerns, the court prohibiting the defense from its Sixth Amendment right. The remedy would be don't call the officer. bottom line is, Orrin controls the decision in this case. The Sixth Amendment is, well, Mr. Troyer's Sixth Amendment right is too important to limit counsel from full cross-examination of this key state witness, and so that's the basis of the court's rulings. Any
Your Honor.
questions?
Your Honor, is the court going to allow them to say that he invoked hundreds of times when that is what the law requires?
That is an incorrect statement of the law. The law never requires an improper invocation of the Fifth Amendment. It doesn't require it at all. It requires a proper invocation, and so I don't agree with the state that he had to invoke. And in fact, how do we know that's true? He didn't invoke when you asked questions, so
Yeah.
obviously he didn't have to invoke.
I understand the court's ruling. We asked 13 clarifying questions. Half of them were about a map, half of them were to explain that the meeting was for the purpose of giving him the transcript. There was one question about the events, about whether or not he saw any neighbors out. That is the only substantive question that we asked him. Asking to clarify a map is not going to cause somebody to invoke. And asking somebody to clarify...
Why not? When the defense asked him to draw the map, he invoked?
He has to invoke under the law for the attorney to be able to challenge the court's decisions on appeal. He has to invoke to preserve that challenge, right? And not invoking when someone's like, well, can you clarify the map? I think that's entirely different. And I think when the jury hears that this witness invoked 300 times, the prejudice of that is just insurmountable.
Defense?
I just think she's wrong. No offense.
Any legal analysis to go along with that?
That's great.
The fact that
Court's ruled.
he has to invoke to preserve the issue for his attorney to argue an appeal, that's great, and I understand that, but he didn't do that when the state asked him questions, which is what this court has just gone over very carefully.
And ruled on.
And ruled on very carefully. So I'll sit down.
He invoked for every question at the prior proceeding. It is misleading and prejudicial to argue to this jury that the defense was somehow here treated differently by Officer Lawless than the state. We asked him one question about the event, about whether or not he saw any neighbors when they were out in the cul-de-sacs. The other 12 were clarifying an exhibit that he drew, which was unclear, and we simply asked him to clarify it and to indicate why we met him previously. That is not about the event. There was only one question about the event. Did you see any neighbors? And he indicated no. And that was it. But they are targeting this officer and besmirching his reputation for following his attorney's advice. And the attorney has a right to say, you got to invoke for every question. Because again, I agree that the court's rulings were correct. But I also believe that the attorneys, and I know that the attorneys invoked to preserve their right to argue that the court was wrong. They have to do that. But instead, the jury's going to get this unbelievably misleading characterization at the end of trial, because that's when they filed their brief, that this officer and this officer alone refused 300 times to answer questions. That is highly misleading and prejudicial. And it's not what happened here.
Why would the witness not invoke today?
I'm sorry?
If the witness wants to preserve what he...
Because it's already, sorry.
What? Okay.
Because it's already been preserved. He's going to be asked all of the same questions about the event. There's no reason for him to invoke today.
Well, wasn't that preserved at the prior proceeding before the deposition?
A proceeding that has limits in terms of how the state can use it. For instance, as you know, whether or not the state can even use that during an appeal. It is a Let's just call it a closed proceeding. That closed proceeding cannot be used for anything other than the purpose it was used for,
Without permission of the court.
Right.
which we don't have, Your Honor. And the attorneys knew that that was a closed proceeding, and those attorneys that invoked, they were the same attorneys at that proceeding. And they know that that is a closed proceeding, that a court may or may not, if somebody were to make a motion, open up. And I think there's a lot of reasons why that would be denied if anybody made that motion. So they preserved their objections during the deposition.
Well, as I said, we have the Sixth Amendment right for the defense to cross-examine a material and essential state witness. And then balanced against that is evidence rule 403 and the concern the state has about potential prejudice that may arise to its case by allowing the defense broad latitude in cross-examination. And as I said before, the remedy is don't call the witness. That's the state remedy. If they don't,
That's not a remedy.
well, if the state's wrong about its analysis of State versus Orne, and if Mr. Troyer is convicted, this case will be overturned because the court would have violated his Sixth Amendment right. And that's a substantial, that's why I provided Orne to the parties to begin with. That was a new case, and the language in there is, it could not be more strong for trial court. So if I had a case, and this is not the state's fault or the defense fault, if I had a case on point with this fact that said, no, judge, don't do this, then at least I'd have some legal basis to say I agree with the state, and I'm going to limit the defendant's Sixth Amendment rights based upon this case. But there isn't a case. And so when you're balancing the fact this trial court, could be making new law, but if I don't have a case, the bias has to be toward the constitutional rights of the defendant. And if I even try to limit what the state's suggesting now about where the defense is going to say 110, whatever the number might be, if I limit that, that could be potentially limiting the defense argument that the witness may be showing potential bias to the defense. And I'm greatly concerned that that is error without some case specifically on point. Good example for the driving while license suspended analysis of Mr. Altimer and the warrant. There were cases on point for that. And so even though the Sixth Amendment was there, the state convinced me, yes, the Sixth Amendment has limits, and on those particular facts, that the defense should be limited on Sixth Amendment. And I suppose the trial judge always is. I'm confident my ruling is correct on that, and I'm not going to reverse that. I'm not going to allow the defense to get into that because it's just beyond, it's just improper character evidence. I don't have that here. And so I understand what the state's saying. It's difficult to predict the full ramifications of the court's ruling right now and to where it's going to go. I suppose you can present instructions if that becomes of necessity, but I've read Orton a couple times already since this was brought up, and I think the Supreme Court's telling me what to do, and that's the reason for the ruling. So I'm not going to limit the state's cross-examination of Officer Lawless concerning potential
defense,
bias.
Your Honor.
I'm sorry, the defense. I won't limit the state's direct either, but I will not limit the defense.
Thank you, Your Honor.
Yeah, we're done with argument, but the ramifications here are not speculative. The ramifications are that we are chilling every person's right, including a police officer, to have counsel and follow the advice of counsel. We are chilling that constitutional right by saying, if you do that and you listen to your attorney, you're going to get attacked about your bias for listening to an attorney. And when the jury hears that he invoked hundreds of times, I know I'm repeating myself, but I don't think it's speculative how the jury is going to improperly, not being lawyers, evaluate that evidence. It's clear how that's going to play out.
The court's concern here is the constitutional rights of the defendant.
Thank you, Your Honor.
Will the court rule on my motion that I mentioned in the midst of my argument, which is that the state shouldn't be allowed to elicit from Officer Lawless that other officers in this case invoked? I'll just fill that in just a little bit more. First, he has no personal knowledge of that. He wasn't present during any of the other officers' invocations.
Is your motion limited to prohibit questioning from the state of Officer Lawless or from recalling other witnesses?
Lawless.
It's
Lawless.
concerning,
Questioning Lawless.
okay.
Lack of personal knowledge. He wasn't present for any other officer invoking. Second, it's hearsay. Because he wasn't present, any information he has about whether other officers invoked is hearsay. Third, it's irrelevant. Doesn't matter one way or the other if any other officer invoked in this case. Officer Lawless invoked based on a personal decision for him. Other officers invoking doesn't matter to this case.
So invalidly invoked,
Either way.
invalidly invoked.
Your Honor, they are targeting this witness,
She's already argued this.
and it is improper to do so. They are making it look like he is the only one who invoked. And there's no question how the jury is going to see that. They're going to think that this officer and this officer only had something to hide. That is what they are going to see, simply because he exercised his right to have an attorney and follow that attorney's right. And it's clear they're targeting him when they argue this and the timing of their brief. And by excluding that evidence, and I don't even know if he knows or not, they are misleading the jury by making it look, and they will argue, or at least make it look like this officer was the only one who did something, and they know that that is not true.
Why can't you call the other officers concerning their invocation?
Yeah, this is the collateral sideshow mini trial that the state is trying to avoid. And as you know, I'm working with a timeline that I can't do anything about, and I objected to having this trial set this late in November for that reason. And to simply recall witnesses and get into, well, did you invoke as well, and why did you invoke? That is so collateral, and it just dissolves into this mini trial, which has nothing to do with whether or not Sheriff Troyer lied.
Defense motion's granted.
Your Honor,
With
I just-
respect to direct examination by the state of Officer Lawless, it's not broader than that. I'm not prohibiting the state from calling other witnesses. But that's not the defense motion, but I want to be really clear. And for the reasons that the defense stated, there wouldn't be any, I was at those depositions. Officer Lawless was only at his deposition, so he wouldn't have personal knowledge about any of them. It would be hearsay that he would have learned from other people, and so for those reasons, it just would not be admissible as to Officer Lawless's testimony.
Will the defense be permitted to invalidly argue that he was the only one who invoked?
Well, no, because that's not
And
true.
that that is a lie?
No, counsel.
I'm making a motion to keep them from arguing to the jury that he was the only one who invoked when they know that that is not true. That is a valid motion. You don't get to
Defense?
make an argument
Well,
to the jury
that's-
that you know is false.
It's premature because you may call the other officers, and
But
it
we're
would be.
not going to call back these other officers and go into this sideshow about other people invoking. We don't have the time to do that, and it just becomes...
Counsel, we have all the time in the world.
We don't, Your Honor. I have a plane ticket to Thailand on December 16th for my father's funeral. That is the timeline.
The Attorney General's office is a huge office, has lots of resources. I certainly don't want to do anything to stop you from going. I respect your need to go to that, but there are other options here, and the personal need of a counsel matters, but not with respect to the trial of the defendant and his rights. So
Your Honor, I'm doing the closing argument. I am the lead counsel. I have prepared that closing argument. It is done. It might be tweaked based on the evidence, but there's nobody else to do the closing argument. I understand Ms. Serrano is here, but she's not the lead counsel here, and she has not prepared to do a closing argument. I intend to do that.
Your Honor, today's the 7th. I think this is premature, like the court noted. And when we did meet before in terms of the trial date, I think the court will recall, we even asked for June. So we're here at the request, please, I'm not done. We did this because this is what the state wanted. We went out as far as they would basically allow. So that's all I have. But the fact is, it's premature, and we would have gone far out from this trial date and this trial session if it had been gone our way, and that didn't occur.
any argument concerning the state's motion that the defense not be able to say that Officer Lawless was the only one who refused to answer or invalidly invoke the Fifth Amendment?
It's premature, but I can't imagine an argument like that being made, frankly, Your Honor. I mean, basically, we're talking about him and what he did and his bias.
Well, and I'm not surprised you said that, but the state's correct. I mean, if the council knows of facts that then you're gonna argue to the, and I'm not suggesting you would.
I never
But
would.
if either side knows of a fact and you're gonna argue to the jury something that's contrary to facts you
I would
know, even
never
if the
do
jury, and I'm not saying you will, but
Okay.
that would be impermissible, and so the state's motion is granted. Any argument would be limited, if, I don't even know if you're gonna make it, but it would be limited to this officer refusing to answer defense questions. And the arguments just show bias. That's the purpose of this questioning.
Right, and I guess I'm saying this, Your Honor, if there's a motion against the other side to say, don't mislead the jury, don't lie, I think that's a given. We don't do that. Ethically, we're bound by the RPCs to present accurately and truthfully. So that's my position, and we're not planning on arguing that because that would be false.
Yeah, state's argument's granted, or state's motion is granted.
Thank you, Your Honor.
Anything else from the defense,
No.
from the state?
No, Your Honor.
Good, recess, okay? All right, yeah, it's time, and so the court's gonna go ahead and take a recess, and please be ready to go by 10 minutes to 10. The court is at recess.
They're on record, Jazz.
Recording stopped.
Testing live stream. Testing live stream.
Okay. Okay, we're good. All set.
All rise. District Court is back in session.
Thank you. Please be seated. Is the state ready to proceed with this next witness
Yes, Your Honor.
Yeah.
Officer Wallace.
and defense? Are you ready?
No issues from the defense. We're ready.
Oh, thank you. Can you bring the jury back in, please?
She can take care of it. Yeah, those are my notes.
And this is witness 11. Jury is returning to the courtroom. Thank you. Everyone may be seated. Members of the jury, I apologize for the delay, but we're ready to go now. So thank you for all being here. The state.
Thank you, Your Honor. The state calls off Detective Wallace to the stand.
Please raise your right hand to be sworn. Do you swear or affirm that the testimony you are about to give in this matter is the truth, the whole truth, and nothing but the truth? I do. Have a seat, please. State your name and spell your last name.
I'm Detective Chad Lawless with the Tacoma Police Department. My last name is spelled Lawless.
Thank you, Your Honor. Good morning, Officer Lawless.
Good morning.
And I'm sorry, it's detective, correct?
Recently promoted, yeah.
What is your occupation?
I'm currently a detective with the Tacoma Police Department in the aggravated assault and homicide unit, and I'm also part of the PC FIT force investigation team.
What is PC Fit, please?
For county-wide response to officer-involved shootings generally, not involving the Tacoma Police Department. If, for example, if the Lakewood Police Department were getting into an officer-involved shooting, we would be a part of the team that would go and investigate.
And when did you become a detective?
I became a detective in October of this year.
And how long have you been a law enforcement officer?
For almost 16 years.
Was all of that with the same agency?
No, I began my career with the Seattle Police Department, went through the academy, and then left Seattle early in my career there and worked for the Ruston Police Department for 5.5 years before being hired at the Tacoma Police Department for the last almost 10 years.
And detective, what is a squad specialist?
A squad specialist is essentially a senior officer on a squad. They get paid, or we would get paid an extra 5%. And one of our duties was in training, like field training of new officers. And also if there was a scene that was like a homicide investigation, for example, we'd generally be tasked with being primary on a scene like that. We'd be like writing the initial general report.
Did you ever have that designation?
Yeah, I was a patrol specialist for 3.5 years prior to becoming a detective.
So was that prior to 2021?
Correct.
And can you tell the jury a little bit about your training to become a law enforcement officer and detective?
So aside from the general basic academy, I've gone through training in interview and interrogation. With my previous agency, I did training for background investigations for police officers, internal affairs. I had first aid training, which is pretty basic, and then I've had a lot of experience as far as on-the-job training, as far as being able to investigate all types of crimes.
Hey, thank you, Detective. I want to talk to you about a call that Pierce County Sheriff Ed Troyer made to Southtown 911 the morning of January 27th, 2021. Do you know what incident I'm talking about?
I do.
Were you working on that day?
I was working that day.
And what shift were you working?
It would be the graveyard shift, so it's 2000 or 8 o'clock at night till 6 o'clock in the morning.
And were you working alone that night, or did you have a partner?
No, I had a partner. It was Officer Ventura.
And have you and Officer Ventura worked together before?
Yeah, we were on the same squad for quite a while, and we decided to partner up and become a 2-officer car in a graveyard in the 2 sector.
And where were you and Officer Ventura at approximately 2 a.m. that day?
At approximately 2 a.m., we were at our 2 sector substation, which is roughly about 2-6 in Orchard area, if you're familiar with Tacoma.
And what is a substation?
We have 5 substations total, and then our regular headquarters. And the substations are places where officers can eat, they can take breaks, they can write reports, especially like graveyard. There's not mostly just here is officers, but it's for general duties for our community liaison officers during the day, and place for us to just use the bathroom and general things like that.
And what were you guys doing at the substation at 2 a.m.?
As I recall, I think we were just preparing to have lunch, if you want to call it lunch, at 2 o'clock in the morning.
What happened while you were at the substation at about 2 a.m.?
On our radios, we received a tone, and a tone on our portable radios is basically a call for us to listen. So they're about to broadcast some our dispatch is about to broadcast some important information, and that we need to be listening and responding. We heard the tone, and then we received a call for a help the officer call. The dispatch gave I don't know the exact sequence, but the dispatch gave the address and articulated to us that it was a help the officer.
And Detective, are there different types of tones?
Yeah, there is. For most, I'll use the example. If there's like an armed robbery, they will give a tone, and it'll be like usually like a priority 1 response, and they will give this like long tone, a long beep. They actually call it the beeper, and then they will broadcast the information. Whether it's for example, if it was an armed robbery to a business, they give the business name, who's calling, and hopefully details of like suspect description, maybe their last known whereabouts, so responding officers can create a plan and respond appropriately.
Was this a different tone than you've heard before?
Yes, it was. It's still a beeper. It's still a tone like this, but it's what I found out later was a priority zero response, which is the highest priority of call. I'd only heard it one other time.
One other time in your 16 years in law enforcement?
Correct.
What did you do when you heard the officer needs help call?
Myself and Officer Ventura left the substation quickly, ran to his vehicle, and began to go towards the address of the dispatch call. And he was driving that night, I was passenger.
Were there any other officers at the substation with you when that tone out came out?
Yeah, I believe it was Officer Hobbs and Officer Barron that were also with us at the substation.
And what did they do when they heard the tone?
Same thing. They ran to their vehicles and started towards the address.
And why was everyone running?
When it's a help the officer call, this is like one of the highest priority calls that we would receive. And we're under the impression that someone that we work with or works in law enforcement is in need of immediate help. So we're going to respond as quickly as we can.
Was TPD wearing, had TPD Tacoma Police Department been issued body cameras yet at this point?
Yes.
When were those issued?
Those were issued in the beginning of January of 2021.
And when you ran out to respond to this toned out call, did you have your body camera with you?
I did not.
Where was it?
Just a little backstory as far as with our body cams, we have charging stations set up at our substations. When we are not responding to a call, we will put the body cams in the charging station, and that also downloads the information from previous calls to a cloud-based program. I think it's evidence.com is the program. My body cam was not on my person, it was in the charging station, and videos from previous calls were downloading to the cloud or to evidence.com.
And why is that done throughout shifts and not just a big dump at the end of the shift?
Well, you can do it at the end of the shift, but this was a new technology for us, and the program tend to be a little bit slow. So if we did it, download it at the end of the shift, it might take us past our allotted time that we're working 6 o'clock, and we didn't want to incur any overtime, so we would do it. Our supervisors encouraged us to do it throughout the shift.
When you ran out to this call, why didn't you go back and grab your body camera?
I honestly forgot it. I ran out so quickly that I didn't remember it until I got to the scene that I had forgotten to bring it.
And when you noticed when you realized at the scene that you didn't have it, did you notify a supervisor?
It was a little bit further into the scene as far as chronological order, but yes, Sergeant Storick responded to the scene, and I notified him that I had forgot my body cam, which is part of our policy.
And did you ever face any discipline for forgetting your body camera that night?
No, there was an investigation done by a lieutenant, but no, I didn't face any discipline because I was within we had a grace period with using the body cams because they were kind of a new technology, and then I was found to be within that grace period.
And what was the purpose of the grace period?
Because it being a new technology, it was new technology to the Tacoma Police Department. Our union asked that we be given 16 shifts or 1 month so we would be able to create a muscle memory, for lack of a better term, as far as be able to use the body cams and turning on the body cams when we get on the scenes.
Okay. And I think you previously testified that Officer Ventura was driving, is that correct?
Correct.
Were you in the same vehicle, I assume?
Yeah, I was in the passenger seat.
Okay, and was this a marked patrol vehicle?
Yeah, marked police SUV.
And how was Officer Ventura driving to the scene?
He was running code, which basically like emergency lights and siren, and responding to the scene, trying to get there as quickly and safely as possible.
Do officers drive code to every scene?
No. Most priority calls we're going to run, we call it running priority or running with emergency lights and sirens, but not every call is necessary for us to drive clearing intersections, going through red lights, sometimes going into oncoming traffic to get around existing traffic. We don't always have to respond like that, no.
And what determines when you drive code and when you don't?
It's generally going to be the level of priority of the call. Some calls dictate that we get there sooner rather than later, especially if we know that there's a suspect on scene. Some motor vehicle collisions where there's injuries involved or something like that. Or if we feel like, hey, there's a suspect that's leaving, maybe we should get there, we need to get there faster, so we might change our response.
And when the call was first toned out, you said it was an officer needs help call, correct?
Correct.
Is that all you knew initially when it got toned out?
When we were standing in the substation and this call came out, that's what we knew.
Before you got to the scene, did you learn more information?
Yeah, when we're in our cars, we have a CAD system that basically is going to give us the details of the call, the address, the case number, and there's even like turn-to-turn directions in our CAD systems if we needed it. I did learn like more details of the call, and then as Officer Ventura is driving, then I'm giving him the details as I'm reading them in the call.
And what else did you learn prior to arriving at the scene?
I learned who was making the 911 call or making the call, had created the call basically, the location and some of the details that were involved.
And who was making the call? Who was making the request for an officer needs help call?
Sheriff Troyer was making the call.
And according to the information you received.
Go ahead.
Oh, I'm sorry.
I object to the wording of that question, saying who was the one making an officer needs help request? It's not what happened. There's a lack of foundation of that question.
Overruled.
And based on the information you were receiving there, what was he saying was happening?
He was saying that someone had threatened his life and he had them boxed in at the Deirdre address.
You talked about reading off the CAD system. When you're in the car, do you also get audible information?
Yeah, dispatch will often update us as we're en route to a call of more information that we haven't necessarily like read into the CAD, and they then relay that information as they're getting it.
And did you hear any other members of the command staff say anything during this call?
Of the command staff, as far as like lieutenant, for me, like lieutenant.
Anything above patrol?
Yeah, my sergeant at the time, Sergeant Storwick, was asking who was making the call. It wasn't clear at first whether or not it was maybe an officer working off duty, which happens, like people work in marked cars and uniform off duty, or if it was someone that was off duty at their home. There's a lot of things that it could have been, and he was clarifying who's making this call.
About how long did it take for you and Officer Ventura to arrive at this location?
It was within minutes. I would have to look at like the actual CAD call to be like a most accurate representation as far as like how long it took, but it was within minutes.
Is within minutes less than 5, more than 10?
Less than 5.
And when you and Officer Ventura arrived, were there any other law enforcement officers at the scene yet?
No, myself and Officer Ventura were the first ones there.
How soon after you and Officer Ventura arrived did other officers arrive?
Officer Hobbs and Officer Barron were very close behind us. They had taken a different route to get there, so they were, within a minute of us responding that they were there.
Hey, I'm going to ask the officer, I'm sorry, I keep doing that. I'm going to ask the detective what he saw when he got there. May he step out and sketch it out?
Defense?
No objection.
Granted.
Thank you, and we'll need to mark that. Oh, please. This will be States Demonstrative 17. Can you please please sketch out what you saw when you first arrived?
As far as like, are you talking about an overview of the scene, or, because we arrived and it was, we were parked behind like one vehicle and saw another vehicle, you want me to draw that out, or like an above view of what happened?
I'm sorry, I'm having trouble figuring out the distinction.
You want like a bird's eye view of the scene, right?
I want what you saw.
Okay. Well, it's kind of difficult for me, I'm not an artist by any stretch. Like, we pulled up behind another vehicle and saw a vehicle parked in the middle of the street, and then another vehicle parked nose to nose with that vehicle. So if you want me to draw it.
Yes, if you could sketch that out, please. Are you comfortable sketching it out?
Not particularly, but.
Oh, I'm
I
not-
can get like a bird's, I was thinking more of like a bird's eye view as far as like when we arrived.
Go ahead.
This is not to scale, by the way. So this would be north. Myself and Officer Ventura arrived from the west. What we saw, this is the cul-de-sac, like, this is north 27th. This is, I don't know how to spell it, sorry, Deirdre Circle. We saw a vehicle parked approximately here, with another vehicle parked approximately here, facing each other approximately 50 feet away, and we arrived from the west.
And before you sit down, can you just write in which vehicle was which vehicle?
This is a patrol vehicle. This was Mr. Alzheimer's vehicle, and this was Sheriff Troy's vehicle.
And you said they were about 50 feet apart. Where were they in the street?
They were, much as I'd like kind of articulated here, they're in the middle of the street.
And can you please describe the two vehicles?
Where I remember this was a teal or turquoise Geo Prism. This was a white Chevy Tahoe.
And did there appear to be space for either vehicle to go around the other vehicle?
Oh yeah, absolutely. More than enough space for either vehicle to either turn around and go the opposite direction, past the other vehicle. One of the other.
Okay. And before you sit down, who were the next officers to arrive?
That was Officer Hobbs and Barron. They came from the east, so I'm not sure where they parked their car relative to all this, but approximately here, this is another patrol vehicle.
Okay. And how soon after you and Officer Ventura arrived did Officer Hobbs and Barron arrive?
Under a minute. I don't know, I mean, it was within seconds, not 2 seconds, but 30 seconds to a minute.
Okay, thank you. You may sit down. Thank you for doing that. All right, let's take one vehicle at a time. Based on the information you received from dispatch, who did you believe was in the white SUV?
I believe that to be Sheriff Troyer.
And did that turn out to be true?
Yes.
Was anyone else in the white Tahoe?
Not that I could see, no.
And when you and your partner arrived, did you have any kind of communication with the driver of the white Tahoe?
Initially, when we first responded, no.
And could you see who was in the white Tahoe?
Not from my vantage point. It was a little distance away, and I think the windows are tinted. I wasn't able to see exactly who was inside.
And at some point, were you able to see who was inside the white Tahoe?
Yes, I was.
And how were you able to do that?
The sheriff, I think, opened the door partially and waved at us, or at me, and asked if he could back up.
And how did you respond?
I said in the affirmative, yeah, you can go ahead and back up.
And did he?
Yeah.
Did he appear to have any trouble backing up?
No.
And excluding any police vehicles that had arrived after Sheriff Troyer backed up, could he have exited the street?
Yeah,
Okay. Sorry, I just don't understand the question. I feel like it's vague.
Could he,
If it's vague-
who's he? Could,
If it's vague, I'll rephrase if that's the issue.
yeah, sustained as to who he is.
Okay, excluding any police vehicles that had arrived after Sheriff Troyer had backed up his vehicle, could Sheriff Troyer have exited the scene?
yeah, there was more than enough room to either pull forward and out of the area, perform a U-turn of sorts and drive the opposite direction, back up out of the area.
Okay, let's turn to the other vehicle now. Were you able to see how many occupants were in the other vehicle?
Yeah, I could see one person inside the other vehicle.
Okay, and what was the illumination?
There was the headlights from the sheriff's vehicle and the headlights and spotlight of Officer Ventura in my vehicle.
Okay, and can you explain to the jury what police spotlights are and how they work and where they shine and things like that?
Yeah, they're movable spotlights. They're sometimes on either side of the vehicle. Most of the time, they're going to be on the driver's side. That is a beam that's pretty bright that we will like shine inside of a car to make sure that when we're approaching a vehicle that they're not maybe a suspect's not able to see us on some occasions. We will use it as like especially on Graveyard that we can hide behind a kind of a cone of light that protects us when we're out in the open. And also we are able to illuminate inside the car to see if there's any dangers to us inside.
So does somebody have to turn the spotlight on?
Yeah, somebody would have to actually manually switch the spotlight on.
Okay. Now, you said that Sheriff Troyer backed his vehicle up. When you arrived, did the other vehicle move at all?
No, the other vehicle stayed stationary.
And then what did you proceed to do?
I exited the patrol vehicle on the passenger side and went to the passenger side of the other vehicle that was parked in the middle of the street.
And had you unholstered your gun?
Yes.
Okay, where was your gun at this point?
It's called, if you're not familiar, like a Sewell position, close to my chest, but pointed in a safe direction.
Okay, and Sewell is S-U-L, is it not?
I believe so.
Just for the audio record.
Okay.
Why was your gun drawn?
It was a call initially that we believed that the sheriff's life was in danger. So we're treating this as a high priority call. And we are at that point doing more of a high risk stop on the vehicle, thinking that this is possibly the suspect and believing that they possibly might be armed.
You said the area was illuminated by the spotlight. Did you get close enough at this time to see inside that vehicle?
Yeah, from my vantage point on the passenger side, I could see inside the vehicle.
And what did you see?
I saw a person in the passenger seat. Once I approached closer to the vehicle, I could see newspapers in the back seat.
And I'm not asking you for a number, obviously, but how many newspapers are we talking about?
A lot.
And then what happened next? All right, let me backtrack. What were the other three officers on scene doing?
So Officer Ventura was giving directions to the occupant of the other vehicle, and giving him directions as far as to step out, keep his hands visible, and walk over towards Officer Ventura. Officer Hobbs and Officer Barron were a little bit out of my sight line. I couldn't see exactly what they were doing as we were getting the other subject out of the vehicle.
So what did you proceed to do?
At one point before, are we calling Mr. Altheimer? Am I okay to do that as far as?
Yes, did you identify eventually who was in the sedan?
Yeah, it was Mr. Altheimer, was in the
Go ahead.
Geo Prism. I gave him instructions at one point to keep his hands on the steering wheel because I wanted to make sure I could see his hands. And then that's when Officer Ventura started giving him directions as far as to get out of the vehicle and come over towards him.
Why did you want to be able to see Mr. Altheimer's hands?
Well, the call that we're getting is that there was a threat on someone's life. We need to, for our safety, make sure that if this is the suspect, that he's not armed. And then we can, from there, once we know the scene is safe, then we can conduct like a safe investigation as far as to find out what happened.
And was the scene then secured and safe?
No, not at that point. Once Mr. Altheimer was brought back to the front of our patrol vehicle by Officer Ventura, he was patted down for weapons, which is basically just a pat down of his outer clothing for weapons. Once he determined that he wasn't armed with anything, then we could conduct a safe investigation. We knew that he wasn't armed, so then we could start to talk to him and feel comfortable doing so.
And when this investigation is done, what was your role?
My role was initially to make sure that Officer Ventura was okay where he was at, and then I took up a role of talking with the sheriff about what had happened.
At any point that night, did you downgrade or cancel the tone out?
Yeah. When we were responding there, I knew that based on the nature of the call, that a lot of officers would be dispatched. A lot of officers, deputies, state troopers would likely be en route. It's important to, as once this,
Narrative answer.
Overruled.
Objection
Continue, please.
non-responsive.
Sustained.
What did you do? Did you downgrade the call?
I did downgrade the call.
And my question is, why did you downgrade the call?
Because at that point, I felt that the scene was under control and that we didn't need any more officers on the scene.
And how soon after you arrived at the scene, approximately, did you downgrade the call?
Within minutes. I could look at the CAD call and see, like, give an exact time, but it was within minutes.
And how do you do that? How do you downgrade a call?
Well, my exact words were, "We don't need the whole world here." But the tone is still going on, this beeper is still going on. It will periodically beep to let everybody know that the traffic is closed on that channel, and to not talk, because the officers on scene are the ones that need to be able to talk on the air. And we canceled the tone, but basically saying that the scene was under control and we were then beginning our investigation.
And does that then free up the other officers to do their other police work?
Yeah, we don't need any more officers there. We could conduct a safe investigation with the people that were there, and we didn't need any more. They can stay in their own jurisdiction or their own sector and continue to do their work.
When Officer Ventura began interviewing Mr. Altheimer, did you stay there for a while?
Not a while, not long. Once I worked with Officer Ventura for a little while, so I was very comfortable with him being able to conduct an investigation and speak with Mr. Altheimer by himself.
And were there any other officers there with Officer Ventura?
I believe that Officer Barron was somewhere close to where we're at. I don't know exactly where he was in relation to where we were standing.
So what did you do, as Officer Ventura was doing his interview with Mr. Altheimer, what did you do?
So I broke contact with them and then went to go and speak with the sheriff as far as to find out from him what had occurred.
And how was it determined who would stay with Mr. Altheimer and who would go talk to Sheriff Troyer, the other involved party here?
It really just the way we exited the vehicle, and the Officer Ventura started giving directions to Mr. Altheimer. So that's going to be his job, and then my job is going to go talk to the other party.
The way that you two approached the vehicle, who approached on the driver's side and who approached on the passenger side? The vehicle being Mr. Altheimer's vehicle.
Yeah, I approached on the passenger side. Officer Ventura approached on the driver's side.
prior to you talking to Sheriff Troyer, were you aware one way or the other if anyone else had talked to him?
Yeah, Officer Hobbs, prior to my contact with Sheriff Troyer, I, not directing him, but asked him to go and speak with the sheriff while I made sure that Officer Ventura was comfortable in speaking with Mr. Altheimer by himself.
And before you then went to talk to Sheriff Troyer, did you talk to Officer Hobbs?
Yeah, Officer Hobbs, as I'm approaching, says, "You need to talk to this guy," or something to that effect.
And that guy was referring to who?
That was the sheriff.
Where was Sheriff Troyer when you made contact with him?
He was standing outside of his SUV that was parked on gonna be the north side of North 27th, close to the curb.
And about how far away was that from the Alzheimer Ventura scene?
He had backed up not very far, maybe 70 feet, maybe 60 feet.
And what did you ask Sheriff? As you were talking to Sheriff Troyer, do you recall anyone else being there?
Yeah, Officer Hobbs was standing next to me within arm's length.
Do you know if he was there, Officer Hobbs, during the entire conversation with Sheriff Troyer?
Yeah, I don't remember him walking away. He was there for the duration of the conversation.
And do you know one way or the other if he was listening to this conversation?
Be a great question for him. I assume that he was that he was attentive and listening.
What did you ask Sheriff Troyer?
I greeted him first of all, and I asked him what had happened.
Had you ever met him before?
Briefly, like years ago, but he's been the PIO in the county for as long as I've lived here, and he's on TV a lot. I knew who he was.
When you asked him what happened, how did he respond?
He began to describe to me what had happened that led up to us being there.
And what did he tell you about that?
He described to me that he was at home, and that he had saw a vehicle outside driving in and out of driveways near his address, his neighbor's driveways, and that he left his home to go and investigate. I don't know if he used the exact words of investigate, but he went to go and check out what was going on with the vehicle.
And was that the extent of what he told you when you initially asked him what happened?
No, he said that he had found the vehicle and began to talk with the occupant and to find out what he was doing.
Did he mention any threat at that time?
No, he didn't.
So what did you do?
Based on the nature of the call and the reason we were there, I asked him, did he make any threats towards you? And he said no.
How many times, and then what did you do after that?
I asked a clarifying question, like, did he threaten you, or did you see him armed with any weapons? And again, he said no, but he also said it was clear that he wanted to fight.
And why did you ask him twice whether he had been threatened?
I wanted to make sure that I heard him correctly, that I was getting the right information, because it's pretty critical as far as making the decision if I'm going to be able to develop probable cause to arrest somebody for a threats complaint.
And did he say no both times?
Correct.
Did he make any physical gestures as he was talking to you?
No, not that I remember.
Sorry, this podium's kind of in my way here. Okay, and Officer Lawless, you've testified previously about this event, correct?
Correct.
Okay, and for the most part, do you remember this event?
I do.
If I showed you a transcript of your prior testimony, would it refresh your memory on any details about this event?
Yeah.
Okay,
Objection, he hasn't indicated he doesn't remember anything specific.
That may be premature, so overruled at this time. We'll see what the question may be.
okay. Okay, Detective Lawless, I'll represent to you that this is a transcript from that prior proceeding. And I'll ask you to turn to page 407.
Is it marked?
Not yet. Thank you, Your Honor. It's now being marked as States Exhibit 18. I'd ask you to turn to pages 406 and 407. Read those quietly to yourself, not out loud, and then just look up when you're done reading.
Objection to this procedure, Your Honor. He's not having his recollection refreshed with anything.
I asked him if the sheriff made any physical gestures, and he said,
Understood.
Oh.
So does the court, so objection overruled.
thank you, Mr. Gross.
Thank you for the clarification. Could we
Go
get
ahead. Oh, I'm sorry.
Just the date of the prior proceeding?
July 13th, 2021. Thank you.
So one more time over the pages again.
406 and 407. And Detective, it's been pointed out to me that the page numbers could be confusing. What I gave you, is that 400 pages long? Does it appear to be 400 pages long?
It goes from 335 to 441, or, excuse me, 442.
Okay. And I directed your attention to page 406 and 407. Did you
Correct.
see those page numbers? Okay, and I had asked you just before that, when you asked Sheriff Troyer, did you ever, if he was ever threatened, did he make any physical gestures in response to that question?
Okay.
Does reading your prior testimony refresh your memory as to that event?
It does. I guess I misinterpreted. I thought hand gestures, but he gave a gesture of shaking his head, and shaking his head no.
And was that in response to your question as to whether or not he had been threatened?
Correct.
Do you recall what Sheriff Troyer was wearing?
I recall him wearing shoes of some kind, dark shoes, slacks, look like a button-up shirt, and maybe like a windbreaker type of jacket.
And how far apart were the two of you during this conversation?
Within arm's length.
And this was in January 27th, 2021. Were either of you wearing a mask during this conversation?
No, like, well, this is during COVID times, but no, neither one of us were wearing N95 masks or anything like that, surgical masks.
No mask covering anyone's faces?
No.
Did you have any problems hearing or understanding Sheriff Troyer?
No, I did not.
Oh, sorry.
Objection, foundation.
Overruled.
Objection, leading.
Court will give some leeway. Overruled.
And did you, I heard the answer, but can you repeat it?
No, I didn't have any trouble hearing the sheriff or understanding.
And did Sheriff Troyer appear confused by any of your questions?
Objection, foundation.
Overruled.
No, I didn't gather any confusion coming from the sheriff.
And did he appear to have any problems understanding what you were asking?
No, not that I was able to tell, no.
After this conversation about what had occurred concluded, did you provide any information to Sheriff Troyer?
I informed him of my observations of the vehicle, and it appeared to be someone doing a paper route, that there was, I say, a lot of papers in the back, but over 100 papers in the back of the car.
And how did Sheriff Troyer respond when you gave him that information?
He said if that's the case, then just let him go.
And was Mr. Altheimer eventually released from this scene?
Eventually, yes.
Approximately how long were you and Officer Ventura at this scene before you left?
I think we finally left at approximately 0240 hours, so 2 o'clock, 2:40 in the morning.
And was that after Mr. Altheimer had been released from the scene?
Yes, it was.
Did you and Officer Ventura return to this neighborhood that night? On the same shift?
No, that neighborhood, no. We didn't respond back to that location later on in the shift, no.
Did you respond? Did you receive any information during your same shift? I forgot how to ask this. Pertaining to the parties involved?
Yeah, we received information that was attached to the bottom of the initial call that a newspaper had been thrown at the sheriff's house, actual residence.
And when you say attached to the initial call, I know what you mean, but can you just be clear with the jury what you mean?
Yes, absolutely. The initial CAD call is one case number, and a lot of information is added to this case number. If there's something relevant to the call that's maybe not a part of the initial call, but is relevant because it's the same parties involved, our dispatch will oftentimes just attach that to the bottom of the same call. So it's all comprised into one.
Okay, and without giving me the address, whose home did you go to when you received this information?
I was under the impression it was Sheriff Troyer's house.
And did you go there?
Yeah, we did.
Was Officer Ventura with you?
Correct.
And what did you see when you got there?
We saw a residence with an open driveway spot with no vehicle in it, and a newspaper sitting in the almost dead center in the middle of the driveway.
Officer, do you ever respond to a dispatched call and not write a report?
Yeah, we respond, depending on the area of the city, between 15 and 30 calls a night, and many of those calls aren't there isn't a written report attached to it.
Do they get documented in some other way?
Yeah, in the actual, our CAD system, we're able to write notes. We're able to write, add people's driver's license information, different things like that. So yeah, we can document this in our CAD calls.
Did you write a police report documenting this incident that we've been talking about?
I did.
And when did you write that report?
I wrote that report my next work shift, which was the next graveyard shift, so the next day.
So would that be January 28th? Was it consecutive?
It was, I believe it was written the early morning of January 29th.
Officer, do you remember writing a report in this matter?
I do.
And I asked you a question about when you wrote the report. If I showed you the report, do you think it would refresh your memory on the details of when you wrote the report?
Yes, it would.
Okay, I'm handing you State's Exhibit 19. Take your time and review that. When you're done, just look up, please.
Do you want to read through the whole thing or just we're looking for the?
Just the cover
date and
page.
time? Yeah, the reported on date is 1/28 of 2021 at 04:21 hours.
Okay, so is that when the report was written?
Yeah, that was.
Officer, when you wrote this report, did you have any trouble remembering what happened?
No, I did not.
And why did you write a report about this incident?
Initially, I asked the supervisors that were on the scene. I knew a report would be written in this matter, but I felt, just based on the nature of the parties involved, that it'd be written by a supervisor. I was then directed by my lieutenant at the time, Lieutenant Stark, that he requested that I write the report, which I happily did because I was one of the primary ones there and had a lot of the information. So he directed me to write it, in which I did the previous shift, but he asked that I, prior to the end of the shift where this occurred, he asked me to wait until he heard from me as far as whether or not he wanted me to write it.
Is that why there was a delay in writing it and not writing it on that shift?
Yes.
Objection leading.
Overruled.
Did you do anything prior to writing this report did you do anything prior to writing this report?
Yeah, as far as investigation-wise, I'm not sure I understand the question.
Did you review any information relevant to this prior to writing the report?
Yeah, the body cams that were available to us as far as Officer Ventura's, Officer Hobbs, and Officer Barron's body cameras. So I reviewed at least portions of those to aid in writing my report.
And did you talk to anyone else prior to writing the report?
Yeah, Officer Ventura is my partner, and we discussed in more detail as far as his conversation with Mr. Altheimer, and that's what I added to the police report.
Did anyone review your report before you submitted a finalized version?
Yeah, Lieutenant Stark requested that I send him via email the narrative for the report, so it's not, this is face sheet information like name, addresses, phone number, and usually like there's an offense tab in there. It's the actual narrative of the report. It's just writing where, like, what I did and as far as like the order of events when we were dispatched, things like that.
And did Lieutenant Stark make any substantive changes to the content of that report?
No, it's mostly just grammatical changes and a little bit of the wording.
That's all I have, thank you. Pass the witness.
This to wait till after lunch for cross?
That's fine, Your Honor.
Right. Members of the jury? It's lunchtime, no talking about the case with anybody and no research about the case. And have a good lunch. The jury has left the courtroom. Everyone, you may be seated. Thank you. Anything else before lunch to
It's
state?
just that I was caught off surprise when the podium was still there.
Oh.
Are you wanting it back?
Yes,
Okay, where it was?
I can put it back door.
Very manly of you, thank you.
Sorry. Anything
Very
else?
chivalrous, nothing from the state, Your Honor.
Anything from the defense?
No, thank you.
All right, and you can step down. We'll try to be back here and get ready to go around 1 o'clock, and we'll see you then.
Thanks, sir.
The court is at recess.
Recording stopped.